My name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In today's installment of Scales, or Suwannee County Access to Legal Education series, I am discussing the appointment of an emergency temporary guardian. So first, when might you need to establish a guardianship on an emergency basis? It isn't what you may think. It isn't that a loved one has been in a car accident and is now in a coma. I mean, it could be, but there has to be more. The court must specifically find that there appears to be imminent danger that the physical or mental health or safety of the person will be seriously impaired, or that the person's property is in danger of being wasted, misappropriated, or lost unless immediate action is taken. Oftentimes, an emergency temporary guardianship arises when somebody is in a declining state of health and unable to take care of him or herself. Say they start to miss payments and the electricity may be shut off, or that they may be evicted. A family member may step in, or in some circumstances, a professional guardian may even step in to file for the emergency temporary guardianship. As part of the petition, the petitioner must inform the court whether the petitioner has knowledge, information, or belief that there are possible alternatives to guardianship known to the petitioner, including but not limited to trust agreements, powers of attorney, designations of healthcare surrogates, guardian advocate under Section 744.3085, or other advance directives, and if there are possible alternatives to guardianship, an explanation as to why the alternatives are insufficient to meet the needs of the alleged incapacitated person. Now, I spoke about the different types of advance directives during the first few videos released as part of Scales, and I chose that order because they are such an important part of family planning that is so often underutilized. But if you had a durable power of attorney and a designation of healthcare surrogate, then there wouldn't be a need to establish a costly guardianship case. One thing that a lot of people get wrong on emergency temporary guardianship is that it is not a solution to all issues. It is temporary in nature. It's only limited to 90 days. Now, granted, it can be extended, but generally it's only 90 days. Before the court may appoint an emergency temporary guardian, the petitioner must file a petition to determine incapacity. Now, I'm going to be discussing a petition to determine incapacity in greater depth next week, but in short, it requires 3 different examining committee members to examine the alleged incapacitated person to determine whether the person truly is incapacitated. Today has been a broad overview of what an emergency temporary guardianship is. Now, I did not go into depth of all of the requirements, so if you'd like to read further, look up Rule 5.560 and Statute 744.3031. If you found this information useful, or you know somebody that could benefit from it, please like and share, and definitely follow the campaign's social media and help the campaign. Invite your friends to follow the campaign's social media. If you have a particular topic that you'd like me to address, then send a message through the campaign social media or website, and I'd be happy to film a video on the topic. Just remember that I can't talk about your specific facts, but I can speak in an educational manner. And if you ever miss an installment of Scales, please visit the campaign website to see all of the Scales videos that are available. And remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.